Hello, everybody. Hello, Ava, baby.
And this is on today's pretrial.
It is, Your Honor.
Okay, just a moment. There we go. You are Mr. Franklin, is that correct?
Yes, sir.
I'm waving my hand. You can see and hear me, right?
Yes, sir.
And your attorney is Mr. Settles, is that correct?
Yes, Your Honor.
All right, Mr. Settles, we are here for, it looks like a plea hearing following pretrial today. And your client, this is, by the way, in file 24-14846FH. Your client is over in the county jail. He wishes to enter a plea by Zoom. The record should reflect that both defense counsel and the prosecutor have stipulated the same. I've agreed in this circumstance to allow it. What would you like to do today with regard to the plea, Mr. Settles?
Judge, again, on the record, what had happened is he's charged with the UDAA statute. Within the UDAA statute, there is a provision that the court may sentence essentially as a misdemeanor with 90-day max if this is his first time. And I think that's strictly up to the court. And the prosecutors agreed that that would be acceptable, and I certainly would like to do that. I've talked to Mr. Franklin about his trial rights and about he'd be waiving those trial rights, and he would like to do that too. This is the second time I've advised him of his trial rights because I tried to do this downstairs in district court. District court was very uncomfortable with it because it's framed as a felony. But nonetheless, the second portion of the statute, I still believe is a misdemeanor. It does not require a PSI. Thank you, Judge.
All right, this is a Judge Hamlin case. So your client would also have to waive.
And he will do that.
All right, have to waive Judge Hamlin sentencing in this case as well, because it sounds like you intend to proceed to sentencing today. Is that what I'm
I
hearing?
would like to do that, and I know that I've spoken with Mr. Atwood. I don't think he objects to that. What? No?
All right, let me hear
Okay.
from Mr. Atwood, please.
I don't object, Your Honor, if the court's willing to do it. And just a slight correction, it's not the UDAA statute, it's the unlawful use or the joyriding statute.
Oh,
So as charged, it is a 2-year high court misdemeanor, which would be applicable up in circuit court. It's within the discretion of the court for a first-time offender to sentence the defendant under that statute for a 90-day maximum. I don't know that that changes the character of the statute as being a high court misdemeanor. It does change, obviously, the maximum potential jail sentence. So the court could handle it if the court wants to. I don't object to that resolution here as he is a first-time offender. But as charged and as pled to, it would be a high court misdemeanor 2-year.
All right, so we need to make sure that your client understands that, sir. This is not going to result in a 90 or 93-day misdemeanor, but because he's a first-time offender, the conviction will still be for the high court misdemeanor, a 2-year max. However, the court's sentencing authority would be only up to 3 months.
thank you, Judge.
All right, sir, do you understand the conversation we just had?
Yes, sir.
All right, do you wish to speak with your attorney about that, or you were able to hear us and you don't have any questions regarding what the maximum sentence could be in this case?
Correct, Your Honor.
Okay. All right, it looks like there's an offer that's been made in this case that would allow you to plead guilty to the 2-year misdemeanor motor vehicle unlawful use as charged. However, because you're a first-time offender, the maximum sentence would be no more than 3 months, so the prosecutor would not be arguing for a sentence in excess of that. The fine for same would be a maximum of $500. Knowing that, sir, do you wish to accept the offer from the prosecutor?
I do, Your Honor.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, sir, you read and understand the English language, correct?
Yes, sir.
Okay, you can put your hand down. You can hear and understand me now, is that correct?
Yes, Your Honor.
Mr. Settles, as your attorney, you've had a chance to discuss with him the charges that have been filed against you and any possible defenses that you might have to those charges, correct?
Yes, Your Honor.
And you're satisfied with Mr. Settles' advice, true?
Yes, Your Honor.
Were you on probation, parole, or bond at the time this crime was committed?
No, Your Honor.
Now, do you understand this arrangement that I've discussed with regard to this? I'll call it a plea deal. That is a sentencing limitation. Do you understand what we've discussed, that the maximum sentence here is 90 days in jail?
Yes, Your Honor.
Have you had any drugs, alcohol, or medications that might affect your judgment in the last 24 hours?
No, Your Honor.
You understand that at each and every phase of this process, you've got the right to your own lawyer, and if you can't afford one, that I would appoint one for you at the published expense?
Yes, Your Honor.
Have you had a chance to review an advice of rights form, counsel?
Judge, I have not, well, he may have reviewed the advice of rights form down in district court, but I have not reviewed, I have reviewed his rights, yes, but not the form.
Let's go through it. Sir, you do have some rights you're giving up. Those rights relate to trial. By entering this plea today, you give up the right to be tried by a jury. Has anything been promised to you, or have you been threatened or coerced in any way to get you to plead guilty?
No, Your Honor.
Is it of your own free choice and free will to plead guilty today?
Yes, Your Honor.
And are you doing so because you are in fact guilty?
Yes, Your Honor.
Let's go ahead and talk about what happened then. According to the information, you were in Traverse City on or about January 30th of 2024. And is that true?
Yes, Your Honor.
On that date, did you get yourself involved with a tan 2005 Jeep Liberty?
Yes, Your Honor.
You recognize that vehicle was owned by another person, specifically Tricia Martin, is that correct?
Yes.
Did you have authority to take or use that vehicle?
Yes.
Counsel?
Thank you. And you had authority to, I think you picked that vehicle up in order to change the transmission fluid for Ms. Martin, is that right?
Yes, and a few other things as well.
Okay, and you were going to work on the vehicle at Safe Harbor and return the vehicle at 5 o'clock. Wasn't that the deal?
Yes.
And you ended up picking up someone else, didn't go, well, you may have gone to Safe Harbor, but you ended up going to the Pines and got the vehicle stuck. Is that correct?
Yes.
And then you called Ms. Martin and told Ms. Martin you would have it back later. It was stuck in the Fife Lake. Isn't that right?
Yes.
And that was not true because you were actually in the Pines at the time.
Correct. I said that in order to keep her from getting irritated or upset with me.
Well, she got irritated and upset nonetheless and called the police, and the police found you in the car at the Pines, right?
Yes.
All right. And you would agree that that was beyond the authority that you were given for that particular car?
Yes.
Thank you. I think that satisfies it.
And sir, you haven't been convicted of unlawful use of a motor vehicle before, is that correct?
That is correct.
All right, any additional questions regarding a factual basis for the defense?
No, thank you.
For the people?
No, satisfied, Your Honor.
Do the parties believe the court has complied with MCR 6.302?
Yes.
Yes, sir.
All right, sir, it's now up to you. As to the charge that you did on or about January 30th of 24 without authority and without intent to steal, take, or use, that you were a party to such unauthorized using or taking of a motor vehicle. That is a 2005 Jeep Liberty belonging to Tricia Lee Martin, contrary to Michigan law, that being a 2-year high court misdemeanor in Michigan. How do you plead?
Guilty.
Well, based on our discussion, it's clear that you understand your right to counsel. It's clear that you understand the rights you're giving up by taking advantage of this plea agreement. And it's also clear that you violated the law in the manner that we discussed. Parties have discussed going directly to sentencing. In this case, I'm going to go ahead and grant the request to do so. Is there any claim for restitution, or is there a victim in this case?
I don't think we have either here, Your Honor.
All right. I suppose I should ask whether the victim has been communicated with in this case and wishes to participate, or is at least aware of her rights as a victim.
We have definitely made her aware of her rights as a victim, and I don't believe she's requested those rights here, but I'll double check. No, we have not heard that.
Okay. All right, in that case, do the people have any argument regarding sentence?
No, Your Honor, thank you.
Let's go ahead and hear allocution, please.
Judge, he's been in jail for 46 days on this, on a 90-day offense. I would ask the court to sentence time served. And his record is not wonderful, but it certainly doesn't suggest that he should be doing more time on this charge. Back in 2014, I think he was sent to prison for a burglary. It's an older record. Okay, here we go. 2022, he may still be on probation. In 2022, out of 88th Circuit, Montmorency, he had a misdemeanor controlled substance use with 24 months of probation. I think that's his last bit. Before that, it said operating while license suspended. And I have operating while license suspended 2018, 2020, and then this 2022. The 4-year bit, I think that was out of state somewhere, and that was a long time ago. And that was a burglary case back in 2013, Judge. And he ended up, looks like concurrent 4 years. I guess he had 2 charges, 4 years imprisonment. I'm not sure out of what state. There you go.
Okay, any additional argument, Mr. Settles?
No, Judge, I would ask for time, sir. Thank you.
All
More
right.
importantly, what I think.
Mr. Franklin, is there anything you wish to tell me before I sentence you in this case, sir?
I messed up. I know I messed up. I apologize to everybody in the matters of this case. I have been given information about my children, so I'm supposed to be gathering my children and starting to reunite with my family again, as well as soon as this case is resolved. Other than that, I plan on doing everything by the book from here on out, and I also have work as well as soon as I am released.
All right, the question before the court is the sentencing of Mr. William Franklin. Mr. Franklin pled guilty to a 2-year high court misdemeanor involving motor vehicle unlawful use. However, because this was a first offense, the court is able to sentence him to no more, if I agree to 3 months in jail and a fine of not more than $500. The court is going to go ahead and do so. The defendant does have a criminal record. It is not insubstantial and does include some years ago a prison sentence and then a series of other misdemeanors, primarily involving motor vehicle matters that caused me some concern, frankly, and certainly would result in some kind of jail sentence under a conviction like this. However, I do think that the amount of time that he served, being 50% of the 3-month maximum that is suggested by the legislature, is proportionate, consistent with the way he presents himself and the seriousness of the case. I will go ahead and sentence him to time served. There are some fines and costs. There is a $50 state court cost, a crime victim's assessment, the amount of $130. He's going to have to pay, what's the misdemeanor attorney fee? He's going to have to pay $500 in attorney fees and a local court cost, the amount of $150, a fine of $100. All of that will be payable to the circuit court. Make consistent payments over time and you won't have any problem. If you avoid it, pretend like it doesn't exist, hope it goes away, there could be a warrant for you and you can be back before me, and I don't want that to happen. I'm sure you don't as well. So you
No,
do
sir.
need to communicate and take that amount seriously.
Yes, sir.
Is there anything else that we need to address in this matter today, Mr. Sellers?
No, thank you, Judge.
And for the people?
No, Your Honor, thank you.
All right, sir, we're going to forward to you an appellate notice. You do have the right to appeal your conviction and the sentence you've just imposed. You also have the right to the assistance of an attorney to prosecute any appeal that you wish to take. If you can't afford an attorney, one would be appointed for you at the public's expense, should you choose to appeal. But if you'd like to appeal, you'll need to sign the document we send over, submit it to the court, to your attorney, to the jail within the next 6 months, or that appeal is waived. You understand, sir?
Yes, sir.
All right, anything else for the record, for defense
No, thank you very much, Your Honor.
and for the people?
No, Your Honor, thank you.
All right, sir, we'll process the paperwork. You should be out here shortly.
Thank you again.
Thank you, sir.
Be safe, be well, sleep sweet, and much love.